Today we are looking at the organisation of the Anglo-Saxon law firm. I think it is fair to say that Anglo-Saxon law firms have tended to dominate the area of international legal advice. This domination is probably linked to a number of factors. First, in the Anglo-Saxon world, a law firm is primarily a business and not a profession. Anglo-Saxon law firms were probably the first to begin to consider the provision of legal advice to be a service and a business rather than a profession. Secondly, the pro-business regulatory environment that exists in the Anglo-Saxon world. The Anglo-Saxon regulatory environment, especially with the development of business structures such as limited liability partnerships, has facilitated the development of large global law firms. Thirdly, people skills. Generally, people from an Anglo-Saxon cultural background tend to be strong in the area of services and person-to-person communication. However, it is important to note that the big Anglo-Saxon firms have enjoyed success in countries all around the world, staffed mainly by nationals of those countries. Thus, we can conclude it is above all the system and methodology that these firms employ that allows them to be successful, rather than the Anglo-Saxon origin of their lawyers. As we noted, it is important to remember that Anglo-Saxon law firms are run as businesses. Anglo-Saxon law firms exist to produce profit for their partners. This can lead to aggressive billing practices, and like all businesses, they seek economies of scale. Thus, they often tend to be in constant expansionary mode, both as regards the number of lawyers that they employ and also as regards their geographic presence. These larger firms are sometimes referred to as full-service firms and offer legal advice in many areas, but generally concentrate on the area of commercial law. To allow for global expansion, these firms have extensive internal structures and can almost resemble a bureaucracy with internal management structures and significant support staff, all of which have to be paid by lawyers billing and pulling in money out in the real world. Such structures are believed to be necessary to allow these mammoth firms to exist globally, but they come at a price both financial and psychological. These firms seek to reinforce their international character by trying to develop an homogenized legal services offering. This attempt at homogenizing the area of legal services is undertaken despite the fact that a law firm is above all defined by two things: the individual lawyers it employs and the reality of the market in which it operates. Thus, just because a firm might have a large antitrust practice in Tokyo does not automatically mean that it can reproduce the same success in Washington or Brussels. This may be because the Brussels market is controlled by another firm that, for any number of reasons, dominates the EU antitrust market, but not the corresponding antitrust market in Japan. Consequently, it is very difficult to have a successful worldwide antitrust practice, and inevitably, Tokyo may have to subvention the Brussels office, or Brussels subvention the Tokyo office, if this fiction is to be maintained. This can lead to imbalance at the heart of the antitrust global practice group. In reality, neither the legal market nor the legal product they supply are sufficiently homogenized to support the global homogenized solution that the big firms are trying to put in place. This is perhaps the reality moment that large firms are still trying to get to grips with. However, this is not to say that smaller firms do not exist in the Anglo-Saxon world. Some lawyers work alone and are referred to as sole practitioners. There are also standalone firms which are not integrated into any national or international group or network of firms. There are also smaller firms specializing in one specific field, and they are referred to as boutique law firms. These firms focus on particular areas of law, for example, intellectual property law, labor law, tax law, or mergers and acquisitions. Now, let's look at the business structure chosen by Anglo-Saxon law firms. Anglo-Saxon law firms can take a number of different forms, but most law firms are structured either as standalone sole practitioner firms, in which a single lawyer will work alone either as a general practitioner or as a lawyer specialized in one specific area of law, or alternatively, the Anglo-Saxon law firm will take the form of a partnership. Section 1 of the UK Partnership Act 1890 defines a partnership as the relationship which subsists between persons carrying on a business in common with a view of profit. Thus, a partnership is a firm owned by two or more lawyers. It is not a corporate body, and consequently a partnership does not have an existence separate from its members. As a result, partnerships do not pay corporation tax. Instead, taxes are charged on the earnings of the individual partners of the firm. Thus, like a sole proprietorship, a partnership is a pass-through structure, i.e. the tax liability passes through the partnership structure and is imposed on its members. There are different types of partnership, but generally law firms are structured either as general partnerships or as limited liability partnerships in the UK or limited liability companies in the US. Let's take a look at general partnerships. General partnerships are a particularly flexible type of legal business structure that is easy to create. However, they do have two major drawbacks. First, the liability of the members for the debts of the partnership is unlimited. And secondly, the unlimited liability of the partners is joint and several, i.e. each partner is 100% liable vis-à-vis third parties for the debts of the partnership, even if such debts are incurred by another partner. The issue of joint and several liability meant that the creation of large partnerships was financially dangerous, as each partner was effectively taking on unlimited liability for all the other partners in the firm. This, as you can imagine, had a negative effect on the creation of large global law firms, as partners in, say, the Tokyo office would not want to be responsible for losses caused by a Swedish partner that they might not even know. As a result, a new type of partnership, referred to in the UK as a limited liability partnership and in the US as a limited liability company, was created. A limited liability partnership is a sort of hybrid structure combining the most positive aspects of a partnership insofar as they are treated as pass-through structures and taxes have only to be paid once and thus no corporate taxes paid, and the most positive aspects of a limited liability company insofar as there is limited liability as regards the debts of the partnership and the debts of other partners. Thus, an LLP gives partners limited liability, but the structure continues to be taxed as a pass-through structure. This, as one can imagine, makes such structures very popular indeed, at least from the point of view of lawyers. We hope you enjoyed this introduction to the Anglo-Saxon law firm.